All right, I'm going to dive right in. Thank you all so much for joining us for the 2025 Texas Legislative Session preview. My name is Sipra Boyd. I'm one of the shareholders in the POA section of Roberts, Markell, Weinberg, Butler, Haley. Always excited to talk about education and to give you guys information about what is coming up and things that we've learned. I was surprised to see the number of bills that are already filed in the legislative process. And so I want to get started quickly because there's a lot of information. Of course, we don't know if any of these are going to actually pass the legislature and get approved by the governor, or maybe they could get vetoed. We never know. It's always a last minute thing, but we do want to talk about them and potentially how they either negatively, positively, or are mostly neutral on how the association is going to be impacted. All right, this information is the information that we're presenting today is based on the law that it exists as of today. Obviously, this is for educational purposes and it does not constitute legal advice. If you have any specific questions that relate to your association, or if you need legal advice, we would always encourage you to contact the association's lawyer and talk about the specifics, because as you know, every fact matters and makes a difference when it comes to legal advice. For the agenda today, we're going to talk about the key dates in the legislative session. I'm going to touch quickly on the legislative process. It's pretty complicated, but ultimately, we just want to hit kind of some high-level points on how a bill makes its way and becomes a law. And then we're going to do a little bit of a deep dive into the bills that we've seen filed this legislative session. For the key dates, Monday, November 11th is the first day that legislators may file bills, and this is the 89th Texas Legislative Session. November 11th is I think it's 6 days after the election, and that's kind of the common day that kicks off the legislative session. Tuesday, January 14th of 2025 is when the legislature actually convenes at noon. And then Friday, March 14th, 2025 is the 60-day bill filing deadline. So a quick 60 days to rush in all these fun bills. Monday, June 2nd of 2025 is Scene DA, which is the last day of regular session. Sunday, June 26, 2025 is the last day that the governor can sign or veto any bills. And then Monday, September 1st, 2025 is the effective days for bills that don't have any specific effective days mentioned in the actual bill. In terms of the legislative process, like I said, filing begins the Monday after Election Day, and legislators can actually file bills up to 60 days into the legislative session, up until the very last minute deadline, which is midnight. And then there are also certain bills that can be filed following the deadline, but we're not going to, again, focus on those. The House, right, the legislative is made up of the House and the Senate. The House members who file bills file the bills with the chief clerk of the House. And then the Senate members, they file them with the Secretary of the Senate. And you'll see this as we go through the bills, but sometimes a bill will be filed with the House and a companion bill or a copycat bill will be filed with the Senate. And I think it just kind of depends on how the bill makes it through each house in order to see which one kind of catches traction the fastest, because it has to go through both processes. But sometimes, again, we see companion bills, and I think there's a hope that maybe one will catch faster than the other, and that's why that happens. In terms of the legislative process, it's impossible for the full chamber to hear all of the bills and make a decision on all of the bills. So there is a committee process. In the House, the Speaker assigns the bills based on the committees, and that is also based on the subject matter of the bill. And then in the Senate, the Lieutenant Governor assigns the bills, and they're assigned to the proper committees. And then there's also unofficial subject matter committees as well. Floor action begins with the second reading. The bill can be amended on the second reading by a simple majority vote. And then the vote for the final passage is held on the third reading. The Texas Constitution actually requires a bill to be read on 3 separate legislative days, and I think that's because there's legislators coming and going, working through the entire legislative process. And then upon passage, the bill moves to the other chamber, right? If it starts in the House, and then it goes to the Senate, and then if it starts in the Senate, it goes to the House to start the process again. Texas legislative process. So many bills will pass one chamber, but it may not be considered in the other chamber. And so it's a very kind of complicated process with the going back and forth. And only if the both houses agree on the final bill and the version of the bill will it be signed or enrolled and then passed on to the governor for either approval or veto. Unless both chambers or the originating chamber agrees on any of the amendments that might be made, then obviously it won't be enrolled, and there's still going to be an opportunity for the bill to die without it making through the process. This is just more about the committee process and the amendment process. There's obviously special committees, conference committees that get assigned in order to talk about any amendments to the bill and any disagreements to the language of the bill. And like I said, unless it's accepted in its final form and enrolled, it won't be considered. The governor has 3 options when receiving an enrolled bill, and he can either sign it, veto it, or allow the bill to become a law without signature. So once it gets to him, he doesn't even actually have to approve it or sign it in order for it to become law. If it gets past that deadline, it automatically becomes law unless it's vetoed. Most of the bills, this is an interesting statistic, are enrolled within the final 10 days of the session. So there's a lot of work that goes into gearing up for those final 10 days. And that gives the governor 20 days after the final adjournment to make a decision. We talked about those key dates in the beginning. If the bills are enrolled in those final 10 days, then the governor only has 10 days. And then finally, the legislature can overturn governor veto of bills during the session with a 2/3 majority vote in each chamber. There's a process chart for both the Senate and the House, and this is all information that's available online. If you're interested in the legislative process, I would encourage you guys to look at this. And it's crazy, the process that each of these bills goes through, but there's a lot of work and time and energy and resources that go into reviewing these bills and talking about these bills and potentially making amendments to these bills. All right, so I'm going to dig into the meaty stuff. Like I said, I was surprised at everything that's coming through. Obviously, there's some bills that we see every legislative session, and the first one that I'm going to talk about is one of those, and that's House Bill 294, or its companion bill, Senate Bill 141. This is the famous chicken bill. On the right side, you'll see the authors of the bills. The fact these are all of the status on these bills is that they were filed, and then we're going to talk about just the sections affected. Most of these affect both single family and condo associations because they're in Chapter 202 of the property code. Some of these only affect condos because they amend Chapter 82 of the Texas property code, and some of these only affect single family or townhome associations because they're in Chapter 209 of the Texas property code, or they're proposed to be, not they are in. The chicken, vegetable, rabbit bill, basically it prohibits an association from enforcing a covenant that prohibits either the growing of fruits and vegetables or the raising or keeping of 6 or fewer chickens, 6 or fewer adult rabbits. The association, like many other bills that we saw in Chapter 202, is allowed to place regulations on some of the aspects of allowing these, but obviously we're concerned about the association being able to really properly regulate these types of items, especially if your restrictions specifically prohibit the keeping of poultry or any other types of animals besides domestic animals. While this does impact single family associations, it's proposed to be an amendment to Chapter 202, which would also impact condos. And so that's interesting. But generally speaking, most condos, if you're a high-rise, mid-rise, it's not going to impact you because you don't have any garden area where you could do this. But this is a refiled bill. We've seen it a couple of legislative sessions now, and this is all about, the cottage industry and being able to sustain yourself within the parameters of your home and not necessarily rely on grocery stores or anything like that in order for you to have fruits and vegetables and eggs. All right, so the next one is House Bill 359, and there's also a companion bill, House Bill 517. This would amend Chapter 202 of the Property Code, so it applies to both single family and condominium associations. Essentially, this bill says that an association cannot assess a fine for a violation of a covenant that requires the homeowner to maintain green vegetation or prohibits discolored or brown vegetation or turf. So really, if there's water restrictions in your community or in your city or county that are preventing homeowners from watering their landscaping, their yards, and as a result of the water restrictions, their yards look like crap. Essentially, this bill would prohibit the association from fining homeowners because of that, or because of the way that their yard or landscaping looks as a result of the water restrictions. I think we're seeing some problems with this one as well. We understand the intent. I think all of us are reasonable people. Hopefully our boards are reasonable and we're not going to issue violations, especially in these dire circumstances. But we do want to see some more clarification on what the water restrictions are based on, if it's a specific disaster declaration that maybe the governor makes as a result of some emergency related to the weather, or whether it's just, a water restriction not necessarily related to some type of a disaster declaration. So this one needs some fine tuning. Obviously understand the impact and the purpose, but still needs some work. House Bill 431, this is just an amendment to the existing solar panel bill that's already out, or solar panel amendment that's already previously made and part of the property code under Chapter 202. And all it does is allow for solar tiles to be included in the definition of solar energy device. That's a pretty easy one, and I don't envision that one being a problem. House Bill 621, this again, another bill that's going to impact Chapter 202, which means single family and condominium associations. And I think we've seen this one before as well, maybe last legislative session. This one prohibits an HOA from, again, enforcing a restriction that would prohibit either a governmental official, a candidate that's qualified for an election, from meeting or addressing owners or residents and other invitees in the POA common areas. Like all the other ones, the POA or the association can place limitations on the gatherings. They can require a rental fee or a deposit, limit maximum occupancy for the event, establish hours, specify which common areas are available. And this doesn't generally just apply to any common area, and then require a written reservation or a rental agreement. Again, I think we understand the intent of this bill. We still have some concerns about it and would like to see some more work around the regulations that HOAs can put on these types of meetings. So this will be an interesting one. I think in the from what we're seeing, based on kind of a social media perspective and the way that owners and HOAs are dealing with what's happening, especially in election year, I think this is, obviously a little controversial and could cause lots of issues. It obviously puts a lot of burden on associations to have to regulate this type of activity, and of course is going to require more resources and work, and that's kind of one of the main problems with it. Anytime the legislature tries to put additional regulations on the association, even if it allows us to manage the activity, that means that we're going to have to do more work, right? Creating this policy, requiring this rental deposit or the reservation, and then obviously making sure that it's enforced properly and complying with it is a struggle for associations that are already, you know, hearing issues about raising assessments for general assessment issues, and then also, oh, your rates are too high, and we don't want to pay more. Very burdensome for the association to have to regulate these types of activities. House Bill 918, this is the one, I guess that is a similar one that was filed previously, but it also relates to the peaceful assembly of owners and residents and invitees and guests of the association in the common areas. And essentially it says that the association cannot adopt or enforce a restriction that would prohibit this, including inviting guest speakers, again, official candidates or public officials. This one says without the prior approval of the POA. And then we would also be prohibited from regulating or restricting the content of the owner or the resident's speech. So this one's a tough one. It's a little bit more egregious. Doesn't allow us to necessarily have as many limitations on the assembly or the event, but I think this is not the only one that we're going to see, and we're going to see a lot of pressure, especially coming out of the last few presidential elections, to try and get this adopted and forced on top of associations, but we do see problems with it. House Bill 648, this one's an interesting one, and I don't, obviously we say this every year, we want our associations to be reasonable. This probably came from an issue where, an association may have been being unreasonable and someone was probably drying clothes in public view and they got a letter. And so now we've got a bill that it's attempting to address it. But essentially the association can't enforce a restriction that prohibits an owner from installing or using a clothesline for the purpose of drying clothes. The association can adopt certain regulations that we see in some of the other provisions that are already in Chapter 202. Again, this one amends Chapter 202, so it applies to single family and to condominiums, but we can impose regulations that say, they can't do anything on the property related to this that threatens public safety. You can't, the association can prohibit clotheslines that are on property owned or maintained by the association or located in the common areas. And then the clothesline can't be visible above a fence line, which I think is a great restriction. But what do you do if you don't have a fence? And what do you do if your backyard is exposed to public view? We can't require prior approval. I know for a fact, based on the thousands of restrictions I've read, that clotheslines are, drying of clothes on clotheslines are typically prohibited. So this one's a quirky one, and I think it will impact a lot of us. I don't know how much traction this one's going to get, but we do have some concerns about the bill and some of the regulations that we're going to be prohibited from adopting to control them. House Bill 1087. This one's a concern for us. This one amends Chapter 209 of the Property Code, so it applies to my single-family associations. And this would essentially eliminate the board's ability to appoint a board member in the event of a vacancy due to a resignation. It would require that the board have a special election to fill the vacancy. And then after the election, the board member would actually serve until the next regular election. Obviously, we think that there are lots of concerns with this one. There's already so many issues with our boards trying to find volunteers to just serve on the board. Now the ACC, because they have to be different people. Requiring an election every time that there's a vacancy as a result of a resignation costs time and money. And again, we have to go through the solicitation process, and we're not necessarily finding people that are even interested in serving. So we see lots of problems with this one. It also potentially runs afoul of our boards that only have 3, and then you go down to 2 board members. And as we know, the goal, not even the goal, the law is that you should have 3 directors of any corporation, at least 3. And so if you're faced with a situation where you're down to 2 directors and you're having to hold an election, and you're essentially 60 days potentially without, by the time you have an election, without a 3-member board. So lots of concerns with this one that we would like to, I don't even know that there's a way to save this to make it better. I think this one is, if it doesn't get adopted, we'd be happy. This one's a little crazy as well. House Bill 1133. This one says a POA, an association can't adopt or enforce a restriction requiring a certified swim instructor with training standards that are substantially the same as with the American Red Cross and the YMCA, from basically conducting lessons on an owner's property. There are some restrictions related to this. The instruction for the swim lesson has to be contained in a rear yard and not visible from the street. The swim instruction can only be between 8 a.m. and 8 p.m. And this one is confusing, but the instruction can't be provided to more than 4 individuals at one time during the instruction period. This one applies to Chapter 202, which again applies to single family associations and condo associations. We see all sorts of problems with this. In our opinion, this is essentially allowing a business to be run from a home, which we all know in most of our single family restrictions, those are prohibited. There are some limitations on, when and who and how many. There's another requirement that the individual that's receiving the lesson has to have access to a restroom that's a permanent restroom, whether that's located in the house or the garage or an accessory building. So again, lots of provisions here that appear to look like there's limitations on this, but essentially, what's an instruction period? Can you have 12 instructions for up to an hour between 8 and 8, and each one of those are 4 people an instruction period? Really problematic. Again, this is one we would like to see go away. I don't see any hope in saving this one by clarifying it or putting more additional regulations in it. This one's a concern because it essentially allows a business use on a property. House Bill 1349. This one's a big one. It's the one that was previously vetoed by the governor in the last legislative session. This one passed previously, but then, in that frenzy of bills that were vetoed, it was part of that batch. We tried to get it reintroduced in the special sessions that followed, but it never got traction because of the other issues that the governor was dealing with or wanted to deal with, and so we never saw it, and it resurfaced again. We like this one. There are good parts to it. Mostly the one provision that would make amendments to the perimeter fencing bill that we all have trouble with. It's the security measures policy, which basically says the association can't prohibit a security measure, the installation of a security measure, including perimeter fencing. This one clarifies that and specifically says that the perimeter fencing can't cross an easement or be placed in a location that otherwise has restrictions on it. So that one's a good one. This one also, if y'all recall, requires condos to update their management certificate to include fees that it charges in connection with a transfer, and then also to file the management certificate with TREC. Part of that update requires the condo association to have a publicly accessible website as well, where the condominium documents are located. This is, I think it's almost identical to the one that exists and was adopted maybe in 2021. I don't remember how old it was for single family associations. So we're just seeing the same thing happen for condos. I think this is a good thing. It's obviously going to create some more work for you guys, but it puts information out there in the public realm, and hopefully makes it to where you can point owners that are requesting information to this publicly accessible website. And then also, anyone that's potentially purchasing property in a condominium association has access to the TREC website, and they can see the management certificate and the fees related to the transfer. So that one's a good one. And then this one also addressed the issues with the ACC membership, which we were hoping, again, would pass in the last legislative session. This one allows the association to solicit candidates for the ACC, and then if there's no response to that solicitation, then the board can actually appoint any person to serve on the ACC, and that person can also be on the board. So it removes that limitation that they have to be separate, as long as you go through the due diligence of trying to find someone for the ACC. That one affects, or this bill affects Chapter 82 because of the condo aspect, Chapter 202 for the perimeter fencing aspect, and then Chapter 209 because of the ACC aspect. Okay, the next one. This one's an interesting one. A couple of these are newly filed, so we don't have a ton of information on them. But this one is House Bill 1246. It allows a sheriff's office or constable to enter into a contract for law enforcement services with the POA, and it actually prohibits the commissioner's court from restricting the terms of the contract. And so this one, I know there's some associations that do this and that are interested in doing this, and there's various issues with this. Sometimes there's not even a contract in place if it does occur, or it's a very minimal contract, because we know our sheriffs and constables have sovereign immunity. But we think that it's an interesting one because it prevents the commissioner's court from interfering in that contract, and I guess changing the terms of the contract. So that's the last one that I'm going to talk about. I wanted to save some time at the end for questions. I know I ran through them really quickly. There are several other bills that touch and concern HOAs, and as we get further into the legislative session, we're going to talk about them. I also want to mention that CAI has picked their CAI TLAC Rally Day. So CAI has the Texas Legislative Action Committee, TLAC, that goes down to the Capitol every year in March, and it's called Rally Day. And for those of you that have participated, it's a fun day to see all of your colleagues and board members out there. And it's a way for us to be involved in the legislative process. Essentially, we go down there with information in hand, and we set up times for everyone to talk to the senators and the representatives about our bills and the concerns that we have with the bills, the things that we would like to see either change in the bill, or whether or not we support the particular bill. It's again, a really interesting and interactive part of the legislative process that I think makes a difference for all of us. And, even if it doesn't change anyone's mind, I think is a good opportunity for you to be involved in how a bill becomes a law process. But the day has been picked. It's March 5th, 2025. It's a Wednesday. There's no cost to participate. And every local chapter of CAI usually sends a bus. I know some management companies send buses. So contact your local chapter and see how you can participate, because again, it's a really interesting process. All right. I ran through that really quickly, but I wanted to give an opportunity for people to ask questions. I think as I was talking, I did see some questions come through, so I'm going to try and answer them. All right. The first one, yes, the slide deck can be sent to us. I think Kyle, who's with our marketing team at RMWBH, who some of you know has handled lots of these, will handle sending these out. And we also record all of our webinars and typically make them available either on our website. And there's a lot of information on our website, past webinars. We also have, I think, a YouTube channel where the webinars are on there as well. And so you can have access to that, to these through that. Is there a step in the process where the public can speak for or against these proposed bills? Yeah, so great question. Once these bills go to these committees, there is an opportunity sometimes for the committees where they hold hearings where people can speak for and against these bills. And that actually mentioning the rally day, that's part of the process is us getting in front of the legislators and figuring out when these bills are going up for the committee and making those connections with the legislators and the lobbying team that TLAC uses to get us in front of the legislators when these committee hearings are happening. General public, and whether or not you guys can, I know that these committees are typically open, but let me get more information. Let us get more information on whether or not just kind of generally you can show up and testify. I don't know the answer to that. Usually what happens is we find out that a bill is going to be heard at committee and then there's like a call and TLAC sends kind of a call for action to contact your legislator and either send, a comment or a paragraph about why you oppose or support a bill. And then there's also an opportunity for usually attorneys, but I think that honestly, if a management company manager or even a board member is able to testify for or against a bill, I think that is really important. And so we'll get that information out to you guys. Under developer control, do you think they could still appoint a board member due to a resignation if House Bill 1087 passes? There's always a developer carve out. I don't recall on this one specifically if there is one. I think if there isn't one, we would vehemently oppose this and argue for a developer exception. And I just think there's no way around that. I mean, a developer has to be able to appoint and dictate, how the board is filled, and they're not required to have elections. They're only required to appoint. So as it sits, I can't recall if that's an exception, but we would certainly fight for that exception if it's not there. Have you heard more about possible changes to CH 216? I'm going to have to look at that. I don't know off the top of my head what that means. And then what does CAI stand for? Sorry about that. I think I just assumed it's Community Associations Institute. It is a national organization with local chapters in Texas. There's 4 chapters in Texas, in Houston, San Antonio, Austin, and Dallas. And it's a great, if you don't know about it, learn about it. It's a great opportunity to share and exchange information, to get educated. It provides monthly education programs. It provides certifications for our managers. It's a great organization, and it supports homeowners associations. For bills that have been essentially resurrected from the last legislative session, how likely is passage in your opinion, given the current legislature's makeup? That's such a great question, and I don't know. It's always, it's really always a crapshoot, and I hate saying that. I feel like at this point we should know if a bill will become a law, but there's just so many other things that are other issues that impact what the legislature does and what's important to them. And as we saw in the last legislative session, even after a bill was approved, it was vetoed, and it was unrelated to anything that was in the bill. So I don't know the answer to that question. I would hope once any committee and any legislators see that this is a refile bill, it's exactly in the same form with the exact same language that was previously approved, that it would be hurried through the process and stamped. But even if that happens, I just don't know if something's going to swipe in the last minute and then cause it to be vetoed. So good question. I don't know the answer. Where would I find out more information about House Bill 1246? So there's a fantastic website. It's called Texas Legislature Online, and I'm going to try and see if I can post the link on the chat. But it is not only does it have. Go ahead, Kyle.
Thanks, Sipra. I've got it pulled up. I'll post it for you.
Okay, perfect. Kyle's going to do it. Thank you, Vanna White. It has not only the Texas Constitution and all the amendments and all the property code sections that you can look up for free and the text of them, but the website, what you can do is put in a specific House bill or a Senate bill number and search that bill, and then you can not only see the language of the bill as it was introduced or amended, you can see what stage of the bill it is in the process the bill is in, whether it's been adopted, whether it's been amended, whether it's been enrolled, vetoed. All of that is listed there, who the authors are. You can even get into the nitty gritty and see the votes for and against if it goes through the committee process, and then the votes for and against, or when it goes through the committee process, when it goes through the houses, the legislative house and the Senate. So it's a really interesting website. It has even notes and comments about the bills, the legislative history of the bill, the intent, kind of fiscally, if it's going to impact anything. Lots of information there. So I would encourage everybody to visit it. It's a great website. Is there a way to avoid a board of directors having to sign the Corporate Transparency Act if they are part of CAI? CAI is saying they're trying to get this reversed for HOAs. All right, so this is a non-legislative question, but I'm going to answer it really quickly because we're getting a lot of questions. At this point, our opinion is that there is no way for an association to avoid having to file a report with CTA if you are a corporate entity, and unless you are exempt as a 501c corporation, and some of our associations are, but it's rare, then you have to comply. CIA is attempting to challenge the constitutionality of the CTA, or the application of it, at least to HOAs, but it hasn't. It's gonna be a long process. It attempted to get a temporary injunction to try and prevent basically a court order that allowed for associations not to have to report while the litigation was pending, but that was denied. So again, that's a really specific question that I encourage you to seek legal guidance about, but our opinion is everybody needs to comply unless you're exempt, and the sooner the better, because that December 31st deadline is here, and it does take time to file that report. It's quick and easy, but it needs to be done. Have you heard of any proposed amendments to Chapter 216, which was adopted in 2023 and allows certain older neighborhoods a method for amending restrictions in limited circumstances? I have not. I don't know it off the top of my head, so I will take a look and we can reach back out to you with an answer. Would you recommend? Oh, I lost my place. I'm sorry. Would you comment on Biden-Harris DOA law requiring specific salary, or HOAs required to follow this? I'm sorry, I don't know about that one, so I can't comment. That's another one I can look into. Something tells me it's probably not an HOA required law, but I'll reserve my comment because I don't know about it. Any changes to Title 11, Chapter 209 expected in the upcoming session? Yeah, there's a couple. I think I mentioned the master bill that was vetoed, that would impact some 209 associations. Also, the director vacancy one absolutely impacts 209. And then most of the Chapter 202 bills, which are a lot of the ones I mentioned in this webinar, do impact Chapter 209 associations. So all of them could potentially impact 209 associations. Kyle put in the TLO website. Are the bylaws and other HOA docs supposed to be on a public website? Did I hear that? Yes, that's our recommendation, is if it's a governing document of the association, then it should be on the public website. And a governing document, or actually I should use the term used in Chapter 209, a dedicatory instrument is defined to include bylaws. We actually think anything that's recorded is a dedicatory instrument or a governing document of the association that should be on the public website. The CTA, Corporate Transparency Act, what is the fine for not signing? I think there's not only are there fines, but there's potential criminal penalties. I want to say $1,000 is somewhere in floating around my head, but I don't know for a fact. But there are some major penalties for not complying. And look, I even got a question today that had misinformation. People think that the board members have to give their social security number, or I don't know, rights to their firstborn. It's really just kind of your name, mailing address, or contact information, and your ID number, like your Texas driver's license ID number, and a copy of that. It's not your social security number. It could be your passport, I guess, if you don't have a Texas ID, but it's not as egregious as I think some board members are thinking. I think there's a lot of misinformation out there.
Hey, Sipra.
Yes.
There's a lot of information on our website about the CTA. So there's a little search icon in the top right-hand corner. Just go put in Corporate Transparency Act. You'll see several articles pop up. There's also a webinar on our website as well that everybody can go watch that has all of those details in it.
Perfect. Yes, lots, like I said earlier, lots of information on our website, and both articles and webinars. So again, I would encourage you guys to go there. By public, does that mean the HOA website they must log into would not satisfy this requirement? We talked about this a couple of weeks ago, and there is some language that kind of splits hairs. And so our recommendation is that for there, even any association website, for there to be a publicly accessible portion to it where, let's say, the governing documents will be maintained, that doesn't require logging in. And then behind the publicly accessible part where you log in, that's where, if you want to put specific information like minutes, any other information, maybe financials, although I've got maybe opinions about financials, but other things besides just the governing documents, the homeowner portal access, notices, or anything like access to, information about upcoming meetings, ballots, or anything like that, those can be behind. But the public, I don't think it says publicly accessible at all, or maybe it does. I'm sorry, I can't remember. I'm getting it confused. But our recommendation is for there to be an access point where the public can access the governing documents, and then anything that is beyond that should or could be behind a homeowner login. So a board would need to pay to create and maintain their own website other than, no, it can be a management other than, the question is other than what the management company provides. No, it can be the management company provided website can comply with the publicly accessible part of it on the management certificate, if I recall correctly. All right, any other questions? I don't think I see any. I've given y'all about 15 minutes back today. I want to thank everyone for, again, attending and just participating in the conversations. I appreciate the questions because I know other people are thinking some of the same things. We're going to keep doing these every so often as more bills get filed. And then certainly once the legislative process starts and the legislature convenes and we see more movement through the committee process and the House process, we're going to keep updating you guys. TLAC is really, really active. And if you go to the CAI website, you can get information about TLAC as well. And I would encourage you to, again, be involved and participate and certainly join us on Rally Day on March 5th, 2025. Thank you so much. Appreciate you. And I hope everybody has a wonderful Thanksgiving holiday. And I'm sure we'll see y'all again soon.